Hello, this is Larry Michelle. I oversee the Unequal Bargaining Power Initiative at the Economic Policy Institute, of which this webinar is a part. I'm also the former president of the Economic Policy Institute. Thank you all for joining us today. Let me just say a few words about the overall project before I pass it on to Wilma Liebman, who's going to moderate the webinar. The Unequal Bargaining Power Initiative is all about noting that the assumption of equal power in the workplace between employers and employees is false, but it happens to be pervasive in employment law, philosophy, political science, and economics. The consequence is to greatly disadvantage the vast majority of working people. Specifically, it creates a lack of freedom in the workplace and beyond. It also undercuts the constitutional, statutory, and common law protections in the workplace. Third, it undercuts civic engagement and representative democracy. It also generates wage and income inequality and wage suppression. And last, it fails to adequately address systemic race and gender discrimination. And as I joke, other than that, it's just fine. You can get more information, EPI's website, www.epi.org/unequalpower. The final act of the project, which is wrapping up this year, is that we are producing a comprehensive volume that will be published in the Journal of Law and Political Economy that identifies the economic claims made in law and economics and conservative analysis to support the idea of equal power. And then we subject those claims to social science evaluation and find that they are not adequate basis for believing that equal power should inform employment law or philosophy. Today, we are discussing a paper by Charlotte Garden on employer suppression of free speech. This elaborates, fleshes out one of the pillars of the project, which is that workplace inequality suppresses freedom. In this case, the freedom of speech in and out of the workplace, including the ability for workers to communicate with each other and people outside of the workplace. I think it's important that we think about not only material inequality, but issues of basic freedoms and how unequal power affects those. So let me introduce the moderator, Wilma Liebman. Ms. Liebman was a member of the NLRB from 1997 to 2011. She was appointed by both Presidents Clinton and President George W. Bush. President Obama named her to be chair of the National Labor Relations Board in January 2009. She's currently president of the Labor and Employment Relations Association, which is a big deal. And I take personal pride in having asked her to become a member of the Economic Policy Institute Board of Directors. Wilma has also been a terrific collaborator and thought leader on the Equal Bargaining Power Project. So over to you, Wilma.
Thank you, Larry, and welcome to everyone in the audience. Thank you, Larry, for imagining this project and for your doggedness in weaving together multiple threads and making it happen. Thank you for involving me in the legal aspects of this project, and thanks to the many contributors who have studied the many facets of the question of unequal bargaining power between workers and their employers, and in particular, have examined a faulty assumption of equal power that is found in multiple disciplines, including law and economics. Today's program, as you said, focuses on one aspect of this inquiry. What rights do workers have to free speech and expression at the workplace and away from the workplace, as on social media, including speech and expression about their employer's conduct, their own working conditions, or their political and religious views? And what rights do their employers have to suppress that speech and expression, or even to compel certain speech or expression of views by their employees? Correspondingly, what rights do employers have to free speech of their own? Our discussion today is framed around a very fine paper discussing these questions written by Charlotte Garden, who is professor at Seattle University School of Law, where she teaches labor law, employment law, and constitutional law. Since 2017, she has been the law school's co-associate dean for research and faculty development. Charlotte is joined by Matthew Ginsberg, who is associate general counsel at the American Federation of Labor and Congress Industrial Organizations, the AFL-CIO, and who before becoming a lawyer was a union organizer. Both Matt and Charlotte are graduates of NYU School of Law, where I now have the privilege to teach labor law to fabulous students, like I'm sure they were. Our third panelist is Maria Soma, who is organizing director for the United Steelworkers headquartered in Pittsburgh, and who before joining the Steelworkers had roles with different women's and community organization, but she has apparently resisted the itch to attend law school. Bravo, Maria. The bios of these three speakers are found in the chat, as well as a link to Charlotte's paper. I will be posing a series of questions for a conversation with the panelists. One underlying theme will be how these issues of workplace freedom of speech, or unfreedom, relate to the overall project's theme of worker bargaining power. Are workers' speech rights reflective of unequal bargaining power? Does employer power to limit employee speech perpetuate or exacerbate unequal power? And put otherwise, is unequal power a cause and or a consequence of free speech limitations or unfreedom? Our speakers will describe the landscape and why these questions matter in terms of the law and real world experience. We will reserve time at the end of the program for the audience. We invite you to put your comments or questions in the chat while the discussion is ongoing. So let me get started and turn to you, Charlotte, to begin. One of the biggest surprises to many people is that they do not enjoy free speech rights at work. Even law students, I have found, seem to assume that the First Amendment somehow protects workers in their speech at work. So let us turn to you. Talk to us about your paper. Maybe you can distill the key points that you undertook to develop, give us some illustrations, maybe what inspired you for this project, and we'll take it from there.
Great, thank you so much. Thank you for that introduction, and Larry, thank you for inviting me to be part of this important project. So, as Larry said a minute ago, the paper is part of the Unequal Bargaining Power project, which explores causes and consequences of the power imbalance between employers and employees. And so I just wanted to briefly situate the paper within the project. First, it's partially an illustration of unequal power in that it explores how employers can use their power over workers to coerce workers' speech or silence. And that's true even with regard to important topics and even with regard to topics that are salient to working conditions, at least some of the time. And then the paper is also an exploration of how employers' control over workers' speech contributes to reproducing the imbalance in bargaining power, especially when law fails to meaningfully check employer control over employee collective action and organizing. And I should just say right here, we're mainly talking about the private sector today, right? We're mainly talking about private sector employers who are not constrained by the First Amendment, though, as we'll talk about later, they have First Amendment protections when the government tries to constrain them. So let me give 3 examples that illustrate the paper's main themes, and then maybe give you a quick caveat, and then we'll dive into the discussion. So my first example is Julie Briskman. You might remember her as the marketing analyst who in 2017 flipped off a presidential motorcade. She was photographed doing that. The photo went viral, and then Briskman was told to resign from her marketing job. She sued, but she couldn't point to a specific legal protection for her off-duty political expression. In the absence of some kind of affirmative protection, what's known as the at-will rule kicked in. And for non-employment lawyers in the room, the at-will rule is the default in 49 states, and it means that employers can fire employees for a good reason, a bad reason, or for no reason at all. Now, the at-will default can be overridden, for example, by laws that say employees can't be fired for particular reasons, like because they belong to a union. It can also be overridden by a contract, including in a collective bargaining agreement, right? So collective bargaining agreements often reverse the at-will default by including a clause that says workers can be terminated only for a good reason. But as Briskman's situation illustrates, there won't always be a law or a contract that constrains employers. So one takeaway is that the at-will default is an important source of employers' power over workers, and that's true as a general matter, right? Not just with respect to speech. So when we talk about employer power over workers' speech, we're talking about one example of this larger phenomenon. My second example is a group of 6 employees who worked for a Jimmy John's franchise, and they were frustrated that they didn't get paid sick days. They had an idea about how to put pressure on their employer. They wanted to generate community support by showing how their working conditions were their customers' dining conditions. So they made some posters that had 2 identical pictures of sandwiches. They noted that customers couldn't tell which sandwich was made by a worker who was sick but came in anyway versus a worker who was healthy. You're about to take the sandwich test, the signs noted. So the workers were fired, and they argued that that violated their rights under the National Labor Relations Act. Ordinarily, that statute does protect workers from being fired because of their collective action about their working conditions, right? So that's a big exception to the at-will rule. But a federal court concluded the workers still lost NLRA protection because of how they went about their protest, right? That is, they disloyally disparaged the employer's product. So this illustrates a second big point, right? Which is that even where there is a law that reverses the at-will rule, its protection can be sort of full of holes, meaning that legal protections can feel arbitrary or illusory to workers who are trying to navigate them. Last, consider a worker in Oregon who was required by his employer to take part in Bible study, and he was told he would be fired if he refused. So this is probably illegal under civil rights law, but the worker had previously been incarcerated, and he was afraid that if he was fired, he wouldn't be able to find any other work. The point here is that even when there are rights on the books, they often still aren't enough to protect workers. Other parts of the Unequal Power Initiative deal with enforcement more explicitly, enforcement of workers' rights more explicitly, but legal and practical barriers to enforcement of rights is also a major background theme of the paper that I wrote as well. The caveat, in addition to mainly being focused on the private sector, I'm mainly focused on what we might think of as socially beneficial speech, organizing speech, collective action to improve working conditions, whistleblowing, opposition to discrimination, and so on. Obviously, there's also some workplace speech that is harmful. Sometimes employers are actually required to put a stop to it. And then there are also a lot of hard cases that fall short of that standard, but that we might still all recognize as harmful. We'll talk a little bit about that category later, though a lot of the discussion today is focused on this kind of socially beneficial speech. So with that, I want to turn it back to Wilma to get us started on the discussion.
Good, thank you for that overview, Charlotte. And for the illustrations, I think they're helpful. So Matt, let me turn next to you. And I'd like to get some sense of why this all matters, particularly in a legal sense. So let me start with the observation that I think many people are surprised to learn that the labor law itself gives protections to non-union as well as unionized workers. So could you talk about what protections U.S. labor law actually gives to private sector employees with respect to free speech rights at work or away from the workplace, whether or not they are union represented? And then maybe comment on whether unionized employees in the private sector have greater free speech rights than at-will employees.
Thanks, Wilma, and thank you to EPI and to Larry in particular for the invitation and for the opportunity to talk about Charlotte's paper, which was excellent and a great jumping off point for this conversation. So yeah, I think you're right, Wilma, that folks are often surprised that unorganized workers have rights under the National Labor Relations Act. But before I dive sort of into that specifically, I want to take sort of a half a step back just to sort of talk a little bit more about the sorts of examples that Charlotte has already raised. and sort of try to define a little bit better exactly what we're talking about. And I know I'm repeating a little bit of what Charlotte said, but we're talking about speech that can be both the sort of speech that employees might have with each other on social media, on a Facebook or Instagram chat, and may or may not have to do with their employment. I mean, it may have to do with politics or religion or what's going on with their kids or their view of what happened on the Grammys last night. There's lots of different speech, some of which could be offensive, some of which could, bear a close relationship to the workplace or not. Certainly, I think when most people think about freedom of speech, it encompasses a broad array of types of speech. There's also that sort of speech when it actually happens in the workplace, in the lunchroom, in a manufacturing facility, on the assembly line. And again, that speech may or may not have a close relationship to what's going on at work, but it also may or may not be really important to those employees, whether or not it bears a close relationship to what's going on at work. And then finally, we have what you've described as compelled speech, where it's sort of from the employee's point of view, a negative speech right. The right to not have to listen to the employer's speech about, say, politics. Charlotte has the example of an employer who required their employees to attend a Trump rally, or to the right not to have to participate in a prayer circle at work that the employer sponsors. So there are aspects of the ability to refuse to participate in compelled speech that are important as well. And of course, the employer may have speech rights as well. So we're talking about a broad range of activity. And I start there because the speech rights of employees depend both on whether they're unionized or not unionized, but also the nature of the speech itself. And so I think it's just important to sort of start there. And the key factor, as Charlotte has already mentioned, is this notion that in the United States, non-unionized employees in the vast majority of states are considered to be at-will employees, meaning that if they're not engaged in a specifically legally protected activity, such as an activity that's protected by, for example, Title VII of the Civil Rights Act, or protected by the National Labor Relations Act, then the employer can decide to continue to employ them or not. So to use the example on social media, if employees are chatting on Facebook about something that happened on television last night, and the employer is really offended by that, if it's not protected by some other statute, there's nothing that prevents the employer from firing them for that. That's sort of the definition of at-will employment. An important distinction for organized employees is that the overwhelming number of collective bargaining agreements that unionized employees have contain just cause provisions. And what that basically means is it's almost the opposite of an at-will employee. It means that if the employer wants to discipline or terminate the employee, they have to have cause, just cause. And the burden is on the employer rather than on the employee to show that there's cause to discipline or terminate that employee. Now, that doesn't speak directly to the matter of speech, because there's nothing at will and just cause are not speech provisions per se, but it matters a lot, because an employee who is disciplined or terminated for chatting on Facebook about, who won Best Country Single last night at the Grammys, and the employer disagrees strongly and fires them, well, an at-will employee may well not have much recourse legally. But that in most cases, that's probably not going to be found to be just cause to fire an employee in a unionized environment. So again, that sort of basic distinction between organized and unorganized workplaces, between at-will employment and employment covered by a collective bargaining agreement containing a just cause provision, is really key. That said, take a breath here, the National Labor Relations Act does protect a subcategory of speech that has to do with employees getting together to work on their mutual aid and protection, to work on to discuss working conditions, wages, hours, and working conditions, And those protections apply both to unionized and non-unionized employees, to all employees covered by the Act in the private sector. And there are some exclusions, but most employees in the private sector are covered. And I think the way I think about this speech is speech that is a predicate to organizing. It has to do with wages, hours, and working conditions. And we as human beings express our views and get together by talking to each other, either in writing or in person or on social media. We communicate with each other. And that speech, that subcategory of speech, is protected whether or not those employees are covered by union contract or not.
So before turning to Maria, I'd like to just drill down on one other aspect of the legal landscape, because I think it's important to have the foundation. The law, the National Labor Relations Act, and the doctrine that's evolved does place certain constraints on employees in their free speech or their ability to engage in speech and expression that is protected. And I wonder if you could talk about that. To some extent, I think it may be a question of employer property or managerial rights, as opposed to strictly free speech questions. But could you kind of describe that landscape, those constraints, both on employees and on the ability of union organizers to communicate with employees they're trying to organize?
Right. So now we're in the category of this activity, which in legal lingo is protected concerted activity, or the question may be whether it's protected, but it's concerted activity having to do with wages, hours, and working conditions, not who won the Grammys last night. And here, the National Labor Relations Board and the Supreme Court over many years has drawn some lines and engaged in balancing of employers' property interest and employees' rights to organize. And so employees, while they have very strong rights to work with each other and speak to each other on the job, may be restrained from doing so. For example, if they work in a sales job, they may be prohibited, lawfully prohibited from engaging in certain otherwise protected speech on the sales floor when there's customers present. And there's a variety of rules that can be specific to the type of workplace or to generally to the employer's ability to get the work done. But those rights generally are very strong. On the other hand, the courts in particular have been very unfriendly to the ability of employees to meet with union organizers at their employer's property. And on the one hand, you might say, well, it's the employer's property, but the fact of the matter is that the most important place for workers to talk with each other and to learn about their rights is at the workplace, and oftentimes that's the only place to do it. And yet, the courts have largely held, with some important exceptions, but largely held that non-employees, union organizers, union staff, even in some case, union members who work for different employers, can be prevented from coming on the employer's property. And so the courts, not surprisingly, given the unequal balance of power in our economy generally, have sort of bent over backwards to put the thumb on the scale of employer property rights. The other place where this comes into play is when employees wish to communicate with each other using some aspect of the employer's property. And so originally the cases were cases about bulletin boards, but who knows what a bulletin board is these days. Nowadays, the cases are about things like employer email. So if you work in a call center and spend your entire shift sitting at a desk on a computer with a headset on, and throughout the day you're chatting with your coworkers, the ones who work across the sales floor from you, via your email or the employer's private internal email device, the view of many employees is, well, why shouldn't I be able to talk about the union? And so this is an important issue in which the National Labor Relations Board has gone back and forth a couple times But the Republican boards have said, well, no, that email system is the employer's property, so they can prevent the employees can talk about other things, but they can't talk about the union. Whereas during the Obama years, a decision called Purple Communications came down, which said employees could, in most instances, speak with each other over the employee's email. And so I think this is an important area, particularly as workplaces move from in many instances, from brick and mortar type situations to a more virtual world where these issues of speech versus property, or how the two should be balanced, become particularly important.
Thank you. That was very helpful, very comprehensive, Matt. And by the way, just to show you how extreme it can get, when I was on the board and in the minority during the Bush years, the majority actually once held that an employee who took a piece of scrap paper to write a union meeting notice and put it on the bulletin board in the break room could be fired for taking a piece of scrap paper. That's the employer's property. So Maria, let's turn to you. And let me just ask the broad question. How does what Matt has just talked about play out in reality for union organizers, and why do these questions matter? And so just to drill down a little, what are the real limitations you have faced on your ability to communicate with workers you're seeking to organize?
Thank you. And I'll add my word of thanks to EPI and Larry and certainly you, Wilma, but for the invitation to be part of this panel. I'm not an attorney, and I'm glad you said that. So I won't cite case laws. I'll give you what real life experiences are for those of us out in the field. And I think a direct answer to your question is that it impacts our work every day. The ability that I heard a couple of things that came out, and certainly in what both Charlotte and Matt said, right? And so when we look at this question of free speech, right, we look at the ability of organizers to be able to have access to property or access to certain things in which to communicate with workers where they spend, in a lot of cases nowadays, unfortunately, a majority of their day is spent in their workplaces. And so not being able to access them during that time and the limits that are put upon us certainly is difficult. But there are other tools now, and I think both Matt mentioned it in terms of, what used to be, or you mentioned it, Wilma, a scrap of paper or an employer email. Now there are other tools in which we can communicate with people. So the question around those things often also interfere or impact with our ability to not only communicate, but then the freedom that workers would have to communicate with each other. And this is really where it comes. I'll cite a very specific example, and it came to mind when we were talking about cell phones, or someone was mentioning cell phones you have. So some of the employer's property is really the employee's property. I had a case where they were given a certain amount of money, a certain reimbursement for the use of their personal cell phone to be used during work hours, right? And so these are employees who voluntarily said, okay, I will take the $50 a month and will use my cell phone as a form of communication. But it's also their personal cell phone number, which the employer has access to, in which to communicate with them. So we have a text group that has been created amongst this group of employees. And within that private text group where they're talking about supposedly protected concerted activity, issues that affect them at work, someone shares this text with the employer and the employer acts against an employee for, right? They said, on work time texting in a group with workers. Now, it's their personal private telephone number that they have allowed the employer to use to which to communicate with them. It's a private text group that they have created amongst each other, and it's using protected concerted activity. And so that is one very simple example of how complicated all these issues that I think Charlotte and Matt have brought forth. Where is the legal standard? Is that private cell phone number the employer's property? Was it their partial property because they reimbursed $50 a month towards those employees for the use of that communication device? Was it permitted to have this private text group within this cell phone system? All these things come into play and they affect the workers. And what that did was have a very chilling effect on the campaign itself. Workers no longer felt free to be able to express their rights and voice their concerns about the issues in that particular case. And I can cite many examples of where, while we have protected concerted activity, this inability for the law, in my opinion, to also catch up with the reality of what workers are facing now is a problem in real life situation. And so those are some of the things that we face. What is the employer's time? What is the employer's property? And what is actually protected? There are other limitations that I'm not sure that I heard, and maybe Matt or Charlotte did mention it, but it's around the issue of disloyalty. If an employee, right, is discussing something, and I thought about this when Charlotte, you were describing the Jimmy John's example, right? And is it showing disloyalty? Is it detrimental to the employer's business? Is it affecting their business, right? When they did that, therefore, is that protected activity? Is that protected speech? And there's a lot of case law around that, but that in of itself is determined by whether that discussion of workplace issues crosses the line into disloyalty or not. And so those are things that I also think about. And when I train and I talk to our organizers and I train our committee, we try to talk about all of these things. And we use the examples that Matt used that says that if you're permitted at work to talk about who won the Grammys last night or how wonderful the Pittsburgh Steelers played last Sunday, right? If you can talk about that over your machine, you should be able to talk about, again, workplace issues with your coworker in those workspaces. But oftentimes the employer, there's a huge burden upon the union or the employee to really make that case that it is protected. And so oftentimes, even though we train our folks on what you can say, it doesn't prevent the employer from being proactive by either disciplining or terminating these individuals. And then 2 years later, we have a fight to get someone back to either have the discipline wiped away or the employee reinstated. And by that time, the campaign is over. So I could go on and on, Wilma, with example after example. But if you want to ask something more specific, and certainly respond.
Yeah, I wanted to drill down just on two different aspects. And I think you touched on the first one, which is to the extent that employees have cell phones and their social media and all that kind of different forms of communicating, how much of a constraint does it place on an organizing campaign to not let employees use the employer's email or to be able to talk during work hours or working time while they are at work? Do these other forms, that's one of the arguments that Republican boards have said, well, there are all these other forms of communication, so it doesn't really impinge on the ability to engage in union activity. Could you comment on that? And then the second question, a little different, but I know you've spoken about this. What are you finding in terms of today's workforce, particularly younger workers, with demographic and geographical differences at play? And how does that factor into these questions?
Factors in quite a bit. And I'm going to start with the second one first, if I may. So, I don't think it's a secret, hopefully not a secret to anybody who's listening to this panel, to realize that how we communicate really generationally is very different than it was even 5 years ago. And so when I'm dealing with the demographic workforce under the age of 30, I know that emails doesn't matter if they have an email, they won't read emails. Doesn't matter that I have access to the employer's email system or their own personal emails, they won't read it. Doesn't matter that I can leave a message at home because nobody has a landline anymore. It doesn't matter that, there are all these different ways in which generations certainly communicate. The other thing that I also think about is when you look at demographics, I think about socioeconomic situations. So we're dealing with some workforce who don't have the money to have broadband or internet, and the only device they have is their phone. And sometimes that phone is turned off If you're living and working in a lower wage, you're probably paying a month-to-month cell phone plan. And there are times when those cell phone plans are turned off. So we have to think about all the limitations that are in play when you're looking at workers, depending on their socioeconomic background, depending on what the wages that they're making at that time with that particular employer, and then certainly generational ages, for me, demographics. That comes in all into play. Having said those tools, right? There are vast numbers of tools. That's true, that people are available to people now, no matter where you live and what generation that you're in. The question is the effectiveness of those tools. And so when, employers used to say, you don't need, that's how we got the Excelsior case, right? You don't need to have access to them. We're going to give you their addresses, and you're going to go after and you're going to knock on their doors, and you're going to be able to visit with them there. All of that may be true, but the reality is that a lot of people spend a significant part of their day at work. The reality is that while they're at work, right, or then it's hard to really reach people. I've got a campaign now where we've got about 400 workers that we're working with in the South, the manufacturing campaign, and there's mandatory overtime. What their workers are telling me is that they have one day off every other week. I had one person I spoke to last week who had one day off in 29 days. 29 days. How do I communicate with that person? The employer basically has captured their lives, their time. And so the inability to speak to them and to use the employer's method of communications in there absolutely limits our ability and the workers' ability in which to enact their rights to try to form a union. And you can't form a union without your coworkers, and you can't get your coworkers unless you can talk to them. And you can't talk to them if there's all these restrictions around. So it really is limiting. Does that kind of get to what you're asking?
Absolutely. And the example you just gave makes me think that that's a good example to test what is an exception to some of these rules, which is if the workers are otherwise inaccessible. Then maybe the union should have a right of access to them on the employer's property. You might give that one a try in this particular case, but thank you for addressing these issues. We have many facets to this discussion, so let me move on a little bit. Let me go back to you, Matt. There is a case that has been litigated before the NLRB recently in Boston involving Whole Foods. Whole Foods disciplined some employees who wore Black Lives Matter masks at work. Clearly, as you talked earlier, employees have the right under the labor law to engage in protected, concerted activities for mutual aid and protection, and that includes expression. But Whole Foods is arguing in support of its discipline, amongst other things, that wearing the Black Lives Matter mask doesn't come within protected expression because it relates to the police and not to the workplace. So tell us how you see this issue playing out. What are the relative merits of the arguments? And maybe you might mention if you know of any other kind of what I would call boundary stretching scenarios that are in play.
Right. So this is a very interesting case and very current. I mean, I think one of the things, sort of piggybacking on what Maria was just talking about, that I increasingly see amongst some younger workers, not in every workplace, but in certain workplaces, is a real concern of bringing social justice issues into all facets of their lives. It's something, I think generationally it is not that hasn't been true in the past, but I think it is more true now amongst a lot of younger workers, and that the boundaries between, home and community and the workplace are perhaps not as clear, that people feel strongly about it, which raises some new issues for labor law. So the way that this issue is looked at is basically, is the activity in the workplace, in this case wearing Black Lives Matter mask and that message, that speech message, is there a close enough nexus between that message and what's going on in the workplace? Obviously the message is one opposing racial discrimination, but the employer says, well, the workers are opposing racial discrimination outside of the workplace. And so the question, the way this has historically been analyzed is, is there a close enough nexus? And in the last decade or two, we've seen a couple of other cases that sort of lay the groundwork for these types of arguments. In 2006 and 2017, there were very large immigrant rights demonstrations known as the Days Without Immigrants, and both of them were opposed to federal policy, were inspired by opposition to federal policies around immigration, and many workers left work openly to support these Days Without Immigrant and were fired or disciplined. And the National Labor Relations Board's general counsel, in both cases, a Republican general, as Charlotte points out in her paper, the Republican general counsel and then a Democratic general counsel found that the nexus between those protests, even though they didn't directly involve the workplace, was close enough to what was going on in the workplace that it was protected activity. In 2006, because the particular policy would have largely criminalized employment for immigrants, and in 2017, because the Trump administration was doing high-profile workplace raids, that the workers could reasonably say, if we don't protest this now, we may be next. And so those are the sorts of questions that are going to be at play in the Black Lives Matter cases that have been consolidated and are being heard now. I'll say one important thing to note is that while the general counsel of the National Labor Relations Board has brought this case and obviously believes in the merits of it, which is great, the employer is making an argument that perhaps plays much more to the judiciary, to the many judges were appointed by President Trump. And they've already said at the National Labor Relations Board, if you rule in favor of the workers here, you're going to be interfering with our First Amendment rights because you're going to be compelling us as an employer to be speaking in favor of Black Lives Matter by requiring us to allow our employees to wear these messages in the workplace. And I think that's an argument that's very much tailored, not obviously to the National Labor Relations Board, who I don't think will be sympathetic to that message, but to the very conservative judiciary that might ultimately review this type of case.
Thanks, Matt. So what about maybe the harder case for us, harder than Black Lives Matter, but the case where where workers' speech is clearly offensive or potentially harmful to other workers. You may recall a few years ago, there was a well-publicized case at Google of an employee named James Damore, an engineer who published a manifesto in which he talked about how women could never be really good engineers. They didn't have the intellectual or emotional makeup for it, that they were neurotic and et cetera, et cetera. And he went on and on about how the workplace was an echo chamber with all very politically correct views. And he was fired by Google. He filed an unfair labor practice charge, and the Trump general counsel did dismiss it, saying that parts of what he talked about was protected, but that he went too far. So what are your thoughts about regulation by an employer of speech that may actually be offensive or harmful?
Right. So I mean, there's no question that there's some overlap. There can be overlap between speech that's that's protected or would be protected by the Act, and that could be prohibited by, say, Title VII of the Civil Rights Act because it's, for example, racially discriminatory. There's an old line of picket line cases where racial slurs are yelled at or screamed at the picket line, and so these are the hard cases. I think one of the things that's important to note is that Title VII has been weakened extraordinarily by the courts since it was enacted. And so oftentimes the employer, if you read the cases closely, you'll oftentimes see the board and the courts commenting, well, the employer sort of found Jesus about Title VII once the employer started organizing a union. In other words, that there was rampant, for example, there might have been rampant harassment going on in the workplace, which the employer ignored entirely until all of a sudden there was union activity going on. And so I think it's important to sort of tease this out. It's an active area in which the courts and the board have been going back and forth in recent years, and I think that's appropriate. But I think, you know, as with most things, it's important, you know, the employer's consistent application of its rules ends up being very important in most of these cases. Yeah.
Thank you. So Maria, let me turn to you for what you're seeing about these kinds of scenarios where employees are perhaps seeking to engage in speech or expression that may be pushing the limit of what has been considered protected under the labor law. What are you seeing, and how do you advise them if they talk to you about what to do?
I do take a fairly conservative approach, to be honest with you, because, you know, people's livelihoods and their lives are on the line here. And so I'd rather them keep their jobs and not, even though we may win at the end of the day, 2 to 3 years later, it doesn't help put food on the table next week. So I take a fairly conservative approach when I'm giving advice to workers. Having said that, you know, we want to make sure that workers have the freedom and to express what is their legal rights. And so I tend to look at it in terms of the reverse. When two thoughts that came to my mind, right? When Charlotte was describing a worker being forced to attend a Bible meeting and not wanting to, and did the employer have that right, and was it an infringement upon their speech? I think of captive audience meetings, right? It's like captive audience meetings where there's only one opinion. I look at that as a religion. Sometimes employers have a religious fervor to keep unions out. And so, you know, those tend to feel like a Bible study to me. And I apologize to anyone on the Zoom who may take offense at that. But I look at those situations where the employer has just so much freedom to push the limit. And what do employees, how far should employees push their rights, and at what risk do they take? And don't get me wrong, there's extreme risk, which is why I am very conservative about what I tell workers to do. However, I do think that Matt has described it perfectly for this generation of young workers whose very lives intertwine, whether they're at work, whether they're at home, whether they're out with their friends, all these social issues. And it is very hard to keep them separate. And in fact, if we do not incorporate them into our campaigns, right, the workers dismiss labor unions as old and outdated and not caring about other issues besides the employer issues. And so we do integrate, you know, some of those issues in the workplace. And I don't have a specific example in which to cite. I will cite the reverse, though, an example of where the employer equated union solidarity, a union action, with a political statement. And that is in a case where we had folks wearing United Steelworkers scrubs as a sign of solidarity, pre-election scrubs. There was no uniform code. We weren't breaching any policy that the employer had. And the employer called us and asked us, actually called an employee in and asked her to go home, to remove her off the floor, to go home, to change, because that was political speech. That wearing a USW scrub was considered political speech. It equated that to Black Lives Matter. Mm-hmm. And they did not want, they were a public-facing employees, and they didn't want the public to get the wrong idea that this employer supported either the unions or Black Lives Matter. And so, you know, that all I think is what we have to look at when we're giving advice to employees as to what the response of the employer could be in this case, what is worth it to the employees to push in terms of their own beliefs of what they feel that they should have a right to say, that they care most about, that affects them in their lives, including their work lives. All of that comes into play as we think about pushing this limits, and then what's protected and what isn't at that time with that particular employer, on that particular campaign, and using what mode of expression that it's going to be. All of that is taken into consideration.
Oh, excellent. Thank you for that. So let me go back to you, Charlotte. And let's look at the kind of the flip side of this question and whether employers themselves have free speech rights, how these issues come up. You mentioned it a little bit, Matt mentioned it. How also do this question of employer property rights factor into the equation? And then I guess I would tack on to that this question that you've also alluded to, you and Matt, which is a book has been written by Alexander Hertel Fernandez called Politics at Work, How Companies Turn Their Workers into Lobbyists. And so do employers have a lawful right to request or demand their employees to support their political candidates or causes? And then do employees have any protections from those pressures if they disagree? So, Charlotte.
Great, thank you. Yeah, so labor law itself protects employers' expression of their views as long as the employers don't cross the line into coercion. And that gives employers so much leeway. They can make predictions about what they see as the undoubtedly dire consequences of unionization, right? And as long as they are making economic predictions instead of threatening, board case law says, well, that doesn't fall on the coercion side of things. Obviously, dire predictions can have big effects on employees, and there's no sort of requirement that employers, review the economic literature and understand, right, whether or not their predictions or their feelings are well-founded. And then employers can also rely on property rights. Matt was talking about this a minute ago, to control who employees hear from, to keep union organizers off their property, to prevent employees from using company resources to communicate, to limit where and when employees themselves can talk about unionizing. And Matt alluded to this fairly complicated set of rules that applies differently depending on whether we're talking about employees who are employed by the employer who owns the property, or a subcontractor employer. So fissuring affects workers' rights here, or whether we're dealing with another organization like a union organizer. Without trying to describe those rules, I'll just emphasize that employer property rights heavily influence labor law rules about what workers can say and hear and when they can say and hear it. Relatedly, employers can also rely on the Constitution, both their own First Amendment rights and also increasingly constitutional property rights. Last year, the Supreme Court decided a case called Cedar Point Nursery v. Hasid, which involved a California regulation allowing union organizers limited access to employer property just to talk with agricultural workers. The court decided this was a taking under the Fifth Amendment, and that means that the government would owe the employer compensation if it wants to keep this regulation in place. I've been focusing on labor rights, but employers also sometimes try to control workers' political behavior, firing them for supporting the wrong political candidate, trying to convince them to vote for the employer's preferred politician, telling them to write to their legislatures to ask for some political intervention that the employer wants. There's no federal statute that protects private sector employees' freedom of political belief and action, but there are state laws in a number of states, and they vary a lot in terms of what they protect. Some bar employers from firing workers because of how they voted or because the worker themselves decided to run for office, and others protect a broader range of political activity. A couple of states bar employers from holding captive audience meetings on religious or political matters. But none of this means that employers can't try to influence how workers see political issues through other channels. And so there's this risk, I think, of creating a political kind of feedback loop where employers try to influence employees to support employers' preferred policies, which leads to policy changes that strengthen employer power and so on. So I'll leave it there, but I would second the recommendation of Alex Hertel Fernandez's book.
Yeah, good, very good, thanks. So Matt, a number of you have mentioned employer captive audience speeches. The current NLRB General Counsel is seeking to limit employers' rights to hold these captive audience meetings. Can you talk to us about the legal issues, her theory, and how do you see these issues playing out, particularly before the board and the courts, maybe even the Supreme Court?
So, I just sort of jumping off from where Charlotte left off, I mean, employers, it's well established that employers have a right to express their views about unionization. And so the board has long taken the position that, well, that means that they can pretty much do it as long as it's not coercive in the sense of threatening, as the board's thought about it. They can pretty much express their views however they like in the workplace. The problem is that employers, and I think there's a sort of common sense to this that's pretty easy to understand, and I hope Maria will get a couple seconds to provide some examples. The problem is employers over the last couple of decades have taken to calling their big groups of employees together, mandating that they come to meetings to be harangued with anti-union propaganda. And they can't not go because they're on the clock and they're being told by their employer that they have to be there. And oftentimes they can't speak. So the notion that the general counsel is raising, which I think it has a very common sense, is underlaid by a lot of common sense, is that is coercive. That when you're in your workplace and your boss says you better come to this meeting, you have to, you must, or else, that's inherently coercive, and that when you pair that with anti-union speech, although the speech in another context might be protected, the context in which it's being made is coercive and therefore unlawful, or at the very least objectionable in labor law parlance, in that it interferes with employees' rights to make a free decision about whether or not to choose to be represented by a union. So, it is a novel theory in the sense that that is not how the board has interpreted the law previously. But I think it has it's a straightforward legal argument that has quite a lot of common sense to it. So I think that she may well succeed with it.
Thank you, Matt. So Maria, talk to us about what is the real world impact on employees of captive audience meetings.
It was one of the most effective tools that the employer has. And so the reality, Matt asked for an example, and I'll give you an example. We were in a manufacturing plant down in Georgia, and the election, we reached, we had an election date. We had 41 days between, a decision on election and the election itself. For 41 days, every single shift, they were mandated to attend a 1-hour meeting per shift every day. After that, then they were required to attend a one-on-one with their supervisor in their supervisor's office, a one-on-one where they could sit and whatever happened behind closed doors. And then their leads were able to walk around the facility and pull people aside and have conversations with them or challenge certain things depending on where you were. Now, I've been a union organizer for almost 30 years, and I would say that in the last 5 or 6 years, what has been happening on the floor is psychological warfare, and those are that's the extreme that I would call it. Because, right, because when an employee who has an 8-hour shift is mandated every shift, every day for 41 days to attend a captive audience meeting, to attend a supervisor meeting, and to have their leads pull them aside maybe every single shift, every day. You can't really call that a free and fair choice. That isn't establishing a laboratory condition. Right? Those are really, you're an employee, you've got, it's the best job in the county. It may not be the best place to work. It's the best job in the county. You don't want to lose it. And you really believe that is not going to have some impact. We have lots of discussion about, treatment of prisoners of war, ethical treatment of people, ethical treatment of what is right and what is wrong. But we don't talk about that in the case of employer-employee relationships. And honestly, when I use the term psychological warfare, I truly mean it. I have never seen such rampant, forceful, anti-union bullying in the workplace and harassment as I have in the last 5 years. And it is horrific. And I really feel sorry for some of these workers. So while the board has protected the employer's rights to be able to have free speech and have this. Certainly, how it is being abused and used cannot be the intent of the act. Cannot be.
Certainly, some of these kinds of employer campaign tactics have been publicized quite a bit in the last year with the campaigns at Amazon and Starbucks. So we're getting close to 5 o'clock. I do want to turn to the audience, but before doing that, what I'd like to do is one quick round with all three speakers to ask you very quickly, give me your final thoughts on one or two questions. The first question was, how does everything we've been discussing today, employee rights to the extent they exist, employer suppression of those rights, and the employer's own free speech rights, what that enables, both in terms of the workplace discussion and unionization, but also compelled political speech that may occur. How do you see these issues of free speech or unfreedom altering the balance of power in the workplace in a way that affects workers' ultimate working conditions or economic well-being? How does it factor into that analysis? And or if you have a quick thought, what's to be done? So, Charlotte, let me start with you.
Sure. I've talked a little bit about how I see this all fitting together with unequal power. So maybe I will answer the last question, what is to be done? And, I think that the way to deal with unfreedom of speech is to boost worker power generally, right? Rather than to specifically target or to pass new laws that protect specific categories of worker speech. So my first bullet point in my notes for this question is just labor law reform. Beyond that, I think there's a lot for states and cities to do to empower workers. New York City passed a pretty robust just cause provision that applies to fast food workers and, targeted or more general legal protections that generally place limits on why employers can fire their employees. I think is a useful thing for states and cities to do, even, that won't get stuck in labor law preemption. I don't think we're going to legislate our way to worker power, but I also don't think laws are relevant. I think it's important to sort of pay close attention to defaults and to enforcement mechanisms when we're thinking about law and workers. The greatest substantive protections in the world aren't going to be that helpful to low-wage workers if enforcement depends on recruiting a lawyer to take a case to individual arbitration. So my last sort of bottom line is, creative thinking about funding and empowering worker organizations as part of enforcement mechanisms.
Thank you. Matt, what about you?
So the great thing about forming a union, and not that legislation isn't great, but the great thing about a union and a union contract is it belongs to the workers in the workplace, and they're not all the same, and it can have what matters to those workers in that workplace. So if you care about sexual harassment in your workplace and you want strong protections, you can put it in the contract. And if you care about racial discrimination and Black Lives Matter, you can put protections in the contract. You can have time off from work to do things in the community. You can build that. And so as a labor movement, I think we are increasingly hearing that from our members, from workers who are organizing that, we've read about in the news, that, that what's important is voice at work and how that voice is expressed, and how that can be negotiated in the workplace, and how workers can build power around the things that matter to them is really important. And so I do think that's a path forward, and that we're going to see new forms of organizing, new contractual provisions, and new victories going forward because of the particular concerns that this new generation of workers has around what matters to them.
Really interesting. And Maria?
Matt stole mine. Get a union and get some protections in the workplace. And while the law says that it's, the employer only has to talk with us, bargain with us over wages, benefits, and working conditions, you know, there is so many things that we can include. And I really think that I would encourage workers, the best protection they have is through a contract. And that that's something that we can do. And no matter what happens in the legislature, no matter what happens in the courts, as long as we've got an enforceable collective bargaining agreement, we can make those certain protections viable and legally binding with their employer. You know, and so I would definitely say that. The other thing that I would say as a final comment really is about balance. We've got to bring back some balance. Larry started us off by saying, you know, there's unequal rights here, and we have to be looking at that. And I would applaud EPI and Larry and Charlotte for talking about, you know, the unfairness of the system. And I really think that the only way to bring some form or some sort of balance is for all entities to really look at how the intent of certain protections and then how employers are abusing the intent of it. And so it's really, I don't think people understand the unbalance of power there that exists right now in workplaces, and that continues, the gap continues to widen, particularly for lower wage workers. And so if we don't do something to have a stopgap to protect those workers, I can't imagine what rights will keep being eroded as more and more workers spend a majority of their life at work.
Thank you, all three of you, Charlotte, Matt, and Maria, for really fascinating discussion, really very incisive. But we're not through yet, because I want to turn to as many of the audience questions as we possibly can. So I'm going to start with a really simple one that even I can answer. And I'll just throw it out for a quick answer. Can employees be dismissed for discussing wages with coworkers? Matt, you take that tough question.
No. That's one of the core protected rights under the National Labor Relations Act. So if you're covered, you're protected.
Yes, thank you. So one question is about remote working. And since it's become more common in an employee's own residence, does that affect free speech with other employees? Let me throw out another question too, so when we can go around. Another question is, do you think that Amazon and Starbucks workers have been successful in their organizing campaigns, partly because they have somehow managed to skirt these legal minefields? And I'll put one more question out there. With the prevalence and intersection of social media in the workplace, how have employers constrained that, and should they be able to? So why don't I start again with Charlotte, and you can address one or more of those three questions.
Great, thank you. Yeah, I think remote work has, raised sort of a variety of challenges, ranging from employees bringing home their work issued computers, raising privacy questions, but also the, using the employer's resources questions, right? So these like employer property rights questions, mixed in with the kind of blurring of work-life boundaries. So I think that is, adds I agree that with the premise of the question, that adds a, sort of layer of complication to a set of, already kind of, sort of challenging doctrines. On Amazon and Starbucks, I mean, I would say one thing that I have noted is that the employers are kind of running the same old, anti-union playbook that we've all seen a million times. And it just seems like the workers are not falling for it. So, I see employers taking full advantage of their own rights under the National Labor Relations Act or under the First Amendment. But employees have had enough, right? Employees are fed up and they are not buying the line. And I've forgotten the last question.
About
social media.
What's that?
Social media in the workplace.
Social media in the workplace, yeah. Have employers been able to constrain that use in the workplace?
Yeah, I mean, there are some, state statutes that limit employers' abilities to access workers' personal social media accounts to sort of kind of surveil them. But on the other hand, there are also employers who want to encourage their workers to be on social media and interact with the company, or workers who have and interacting on social media as part of their jobs. And those workers, especially when they are, sort of acting as like a mouthpiece for the company, are going to, I think, have potentially run into trouble.
Thank you. So Matt.
I mean, I'll just briefly on the social media piece. I mean, one of the interesting changes that I've seen over the last decade is that employers have, by and large, employers where their employees use electronic communication, which is a lot, but not all employers, have gone from prohibiting use of, say, email and social media for non-work uses to doing what we've all done if we have teenage children and throwing up their hands and saying, you can't, everybody's on social media and email all the time. It just is the way it is. Saying no is just not an option. And so I do think it's one of the interesting things in most workplaces, in many workplaces where employees are regularly on the computer or on their phone, they are now allowed to use social media and email and the computers for non-work purposes, because the employers, that's just the way of the world. And it's more efficient for the employer oftentimes. We always use the example of if you have to pick up a telephone and call your spouse to arrange for somebody to pick up the sick kid at school, it's a lot easier to send a text or and a lot quicker, and you can get back to work. It raises a situation where oftentimes I think what we're seeing is employers who in fact are discriminating against the use of those communications for union-related communication. So the employer allows their employees to talk about everything under the sun on social media, except when it comes to the union, and then they crack down. And so we're seeing a lot more of that sort of anti-union discrimination, which is unlawful. It's well established as unlawful under the Act. And so it's sort of just the ubiquity of social media, I think, has sort of changed the playing field.
So, Maria.
Everything that they said in terms of social media, I think you can't ignore it. People are going to use it. Does the employer try to control it? Heck yeah. Do they use it against the workers? Heck yeah. Both in unionized and non-unionized workplaces. One of the things when you mentioned Amazon and Starbucks and what's happening there, both are fairly low-waged employees. Their demographics may be slightly different depending on where they're located. So you've got probably baristas and Starbucks workers. I know this is anecdotal, but I suspect that a lot of the baristas are college educated folks, doing this either as a side gig or in waiting while they're applying for other work, or they've just liked it. You've got Amazon workers who I would probably guess to say that a lot of them, at least in the warehouse and the logistics sides, the warehouse side, aren't college educated. And so you've got a variety of different demographics and situations going on. But what is common of what's happening now and what we can't let go of is the moment in time that we're in. We're in a COVID-related time. We're in a situation where the pendulum is, while there's that, I discussed the imbalance of power in the workplaces. What's happening in the pendulum is the power of the Great Resignation, the power of the red to vote with their feet. Right, employers are having difficulty finding employees, and employees are finding that they can work anywhere. And so this is a moment in time when that pendulum is there, and we can't forget that moment when we're discussing things like Starbucks and Amazon. Between COVID and the pandemic that we've suffered, between what's happening economically now, my fear is the pendulum is swinging back the other way, or could be soon swinging back the other way, and so we're back to really trying to make sure that we're protecting workers in their workplace when they're enacting their rights. So I would say that that the tools workers use nowadays are very different. So the tools that the excuse me, that the union and the employer has to use in which to either communicate or permit the employees to use is vastly different. And again, I don't think the law is caught up, or discussions about kind of limitations around that is caught up yet. And that we are in this moment in time to having this discussion about worker power. We can't forget the pandemic and what's been happening over the last 2 years.
And I'm glad you mentioned that, because I think that this moment is rather unique. Not only it's the pandemic, but the accompanying economic crisis, the democracy crisis, the racial justice crisis, and the climate crisis, all coming together, all with issues that particularly young workers really care about a lot. And so I think it is all of this, it's like a pent-up discontent, and everything that this period has exposed about the inequities and inequalities and the weakness of our social safety net, et cetera. So I'm really glad you mentioned that. So I want to pose two legal questions, one to Charlotte about employers that are forcing people to accept non-disclosure agreements. And they keep their mouths shut when they are complaining about discrimination and et cetera. So could you talk a little bit about that? And then we had one other legal, another legal question I wanted to pose to Matt, which is a Washington state senator has posed the question that she is thinking of proposing legislation regarding captive audience and compelled speech participation, and she's looking for any advice. So I know you know the legal issue to give her some advice on. So first, let me turn to Charlotte.
Sure. Yeah, happy to talk about non-disclosure and non-disparagement agreements. I mean, obviously, they've gotten a lot of attention in the wake of Me Too. And a lot of that attention has been focused on NDAs that employees sign when they're leaving a company, kind of like in exchange for severance or as an actual or kind of a quasi settlement of litigation. Those agreements can co-opt former employees into kind of maintaining this culture of silence about a problematic employer. But there are also NDAs that are imposed upfront as a condition of employment. Sometimes those respond to legitimate employer interests, right, like preserving trade secrets. But at the same time, employees are often just going to sign whatever is put in front of them. And that means some employers impose these just incredibly broad NDAs that sometimes go so far as to prevent employees from ever revealing anything they learned in the course of their work. An NDA that broad suppresses worker power by limiting an employee's ability to go to a new employer in the same field, right? Inevitably, they're going to rely on something that they learned in their old job. And that means that, the employee or the new employer, might fear getting sued. Some California courts treat these really broad NDAs as tantamount to non-compete agreements and say they're unenforceable for that reason. So, there's that. There's a recent wave of state laws that make NDAs unenforceable in some circumstances, right? Especially as they relate to harassment and assault. But, again, like all of this depends on employees knowing that an agreement that they've signed will be unenforceable, right? So, helpful if you can get legal advice or, you just know this area. But, a lot of workers are going to know they've signed these agreements, they're going to act accordingly, whether that means, not applying to a new job, not reporting a problem, right, not going to a regulator because you think your NDA could apply in that context, right, just generally keeping quiet in a host of situations where we would want workers to speak up.
Thank you. Turn to Matt.
Sure. So, a couple observations on the state legislation around captive audiences. So there are a few states who have passed laws that prohibit employers from requiring employees to attend compulsory meetings, religious meetings, political meetings, including meetings about unionization. Connecticut, in fact, just passed such a law in the last week or so. Oregon has such a law as well. Those laws, Oregon's law, for example, has been challenged. That challenge sort of went away on procedural grounds. But there is an issue out there as to whether or not it's the sort of labor relations matter that states should be legislating on, or that exclusively has to be dealt with at the federal level. So you can look at those. It's worth looking at those laws, looking at the Oregon lawsuit. You can get a flavor of that. But I think the good news is, in addition to what the states are doing, is that as we've already discussed, the Federal National Labor Relations Board's General Counsel is actively moving on this. And in fact, if the issue reaches the board and they rule that captive audience meetings are unlawful or objectionable, that would apply nationwide.
Good. And certainly we have seen in the last decade, at least, that with gridlock over federal labor law and almost any kind of federal law dealing with workers, that the states are taking the lead, or at least worker-friendly states are taking the lead in many of these kinds of things. We are getting close to the end of time, but I have one follow-up question for you, Matt, and it's go back to the easy question I posed to you about whether workers can be fired for talking about wages in the workplace. And someone says, we didn't really answer his question because it was a non-union shop. So he doesn't know if it's legal or not. And what can he do to pursue a threat like that? So obviously it applies to union, non-union, but maybe what's the process for challenging some kind of someone who's fired for talking about wages?
Right. So the process. So it is unlawful to fire someone for talking with their coworkers about wages, even in a non-union workplace. And the process for challenging that is to go and file what's called an unfair labor practice charge at the National Labor Relations Board. And the board has regional offices throughout the country, and they have a good website, and you can look up where the closest office is to you. And it's a pretty straightforward. That's a pretty straightforward violation of the law, and the process of filing a charge is straightforward as well. You don't need a lawyer, and if they find merit to your charge, the board's general counsel's office will prosecute that charge on your behalf. So again, you don't need an attorney to file a charge of that sort at the NLRB.
Okay, and one final question. Do you think that many of these problems would be resolved if we were to have legislation that did away with the at-will default rule and impose statutorily a just cause requirement? How much help would that be? Charlotte, and then Maria, and then Matt, and then I'm going to close things up.
Yeah, so I guess I'm going to say it depends. It depends on the details of what this law looks like. So Montana has this, right? Montana got rid of at will and replaced it with this just cause statute. One thing to know about the just cause statute is that it's got sort of limited remedies, and to enforce it, you have to go to court, right? So you have to be able to find a lawyer who's willing to represent you and who can get paid either on a contingency fee basis or, I suppose if you want to pay out of pocket. And that is just not going to be particularly realistic for many low wage workers. And that's before we even talk about individual arbitration agreements. So I'm not saying it's useless, but I'm not saying that it solves all the problems. A regime that, so in a under a collective bargaining agreement, there's a union there that, if something happens to you, they are the ones to hold the employer's feet to the fire under the contract language, and they've got experience in doing that. And there's a procedure in place, that's reasonably accessible and inexpensive, right? So that enforcement mechanism makes a huge difference.
Good. So Maria and Matt, Charlotte's made the case for collective bargaining yet again. Anything to add to that on the question of changing the at-will default regime?
No, kudos to Charlotte for making this statement. The one thing I would add, and that is that the reason why I support collective bargaining agreement or unionization, I shouldn't say legislative or fix to some of this, is because I believe in collective action. I believe that that collective action, you're better taking action as a group as opposed to individual action, be it legal or anything else. And so I think that really is the answer, rather than, I shouldn't say that, not rather than, because I think that any tool that employees have that can be added to their toolbox to help them in whatever situation at work that they need to face, the better off we are. And so having just cause certainly will help, I think, a lot of workers, and the burden being on the employer and not the employee. But I do believe that collective action is really the answer, and through unionization and the protections of a union contract.
Thank you. And Matt, last word?
I have nothing to add to those great statements.
Well, I want to thank the three speakers for really outstanding presentations. I think it was really a very, very rich discussion. I thank the audience for staying with us and for good questions. I hope you found the discussion as interesting as I. And then I turn to Larry Michel for the last word. And thank you again for putting us together.
Yeah. Well, thank you all so much. I just want to make a few comments, which is one, this suppression of free speech is really anti-American at the workplace. People think they have a right of free speech because of the First Amendment, which only protects them against the government. They don't recognize that it doesn't protect their free speech relative to, in the workplace or in and out of the workplace that your employer can suppress. And I think that's something we should articulate. There's also a broader discussion of free speech right now under the terms of cancel culture. So there's a lot of discussion about this. But in all that discussion of free speech in our society, the topic we talked about today is absent. The complete, the ability of employers to suppress the content of free speech and the capabilities of communications. Last, Wilma had asked, does this free speech thing erode union power or worker power, or how do we think about it? And I think the conversation here is that the unequal power in the workplace suppresses free speech. The unequal power is reflected in the at-will doctrine, which claims that an employee's ability to quit is equivalent to an employer's ability to fire you. So they're equal. Now, so that's bad enough in and of itself, that the equal power assumption suppresses free speech. It's then, I think we've shown that it may not be the major cause of union erosion, but it's certainly not helpful, as Maria pointed out. You're walking through a lot of landmines. So the last thing I want to say is everyone should sign up for API social media. There will be a recording of this posted. You'll probably get an email about it. It'll be on YouTube. I want to thank all the EPI staff for helping on this, Emily, Margaret, and others. And with that, follow the Unequal Bargaining Power Project and be well and fight the boss.